SJC-12316, Commonwealth v. Peter Castillo.
Mr. Sheketov, good morning.
Good morning, Your Honor. If it please the court, Robert Sheketov for the defendant appellant, Peter Castillo. I was just talking to my opposing counsel and saying it would be very interesting if the SJC actually submitted questions to us ahead of time so we knew what was on your mind. And we could
You'll find out shortly.
I thought that might be true. I would try.
What's on our mind? It's whatever you brought us.
So I would like to address both issues today, the first being whether or not my client was entitled to an instruction on defense of another. I think my best argument is that he was entitled to an instruction on defense of another excessive force. Defense of another is an interesting concept because it really doesn't matter whether the what we call the third party, the party engaged, the party who you're defending, has the right of self-defense. What matters is what the defendant's perspective is, and whether or not in the circumstances known to the defendant, he would have certain beliefs, a subjective belief, an objective belief, and a belief in the amount of force that is necessary. In this modern era where it's not unusual to have videotape, and in this case, we have two videotapes, one from the fourth floor garage and one from the ground level. One can study the videotape and come to conclusions like the trial judge did that are based on the perspective of the viewer of the videotape, not on the perspective of the defendant. And in fact, in this case, the judge said that he had reviewed the videotape 30 times and had come to the conclusion that this defendant could not have believed, despite what he testified to, what would be necessary for the instruction.
So, I take your argument, Mr. Sheketov, and there's clearly, and I've watched the videotapes, and the judge maybe made an error in focusing more on the videotapes than on your client's testimony. But what role in the third party or defense of another does it have for the prerequisites of self-defense, that being initial aggressor or failure to retreat? I get that, as you open with, it's from the perspective of the defendant, but here we have a situation where it's arguably 2-on-1, and he's the third guy that comes into the fray, and the victim is against a vehicle at the time that he's shot. So where does that whole prerequisite come into play?
Okay, so I believe that if the defendant, the person exercising defense of another, saw the beginning of the fight and saw that his friend, in this case Marlon Ramirez, was the initial aggressor, and saw that the second person, the driver of the vehicle who was in the initial fight, was also there, and saw that the victim was trapped up against the car, I think a reasonable person applying the knowledge that the defendant had would be in trouble, claiming that he was entitled to this defense.
Then what do we do with tests where we have a laser focus? He says he has tunnel vision, right?
Right.
And he just doesn't testify about those surrounding facts, but there's overwhelming evidence from the videos and other witnesses to those events. Do we impute that to the client in the reasonable person standard?
So my argument would be that the evidence has to be taken in the light most favorable to the defendant, so that where there are reasonable inferences to be drawn, some for the Commonwealth, some for the defendant, in the circumstances here, in deciding whether an instruction is required, those inferences have to be drawn in favor of the defendant. I mean, the prosecutor did confront him with the fact that if you look at this videotape, when he was on the witness stand, you can see that the driver is also there. It's not one-on-one, it's two-on-one. And the defendant says, I didn't see that. I was focused on the one-on-one. And I was focused on this guy who was in really good physical shape, who had already hit my friend a couple of times and dazed him. He had obviously hit the other person because he was bleeding from the face. And that's the perspective from which that's the knowledge that I had from which I acted. So because we have a videotape, I don't think it changes the rule that whatever the defendant says has to be taken in the light most favorable to the defendant, because certainly his story is possible.
But it's not only his subjective perception. He may have believed that, but it has to be what an objectively reasonable person would have done in those circumstances, in the position of the defendant.
Right, I agree. But it's not the reasonable person who views the videotape. It's the reasonable person applying the knowledge that the defendant says that he had. So lots of things happen in that videotape. I'm not sure that it's fair to characterize this as other than mutual combat between Marlon and Stephen Perez, the person that gets shot and killed. I mean, when you watch the earlier part of the video, he is, even though his friends are trying their best to keep him away, he wants to go, as somebody is saying, and you can't tell who, round two.
You're right, and after the Lopez fight, there's kind of a lull, and that's when the other group, including your client, comes in after being telephoned by
Correct.
by Lopez, right?
That's true, and it's not clear that my client doesn't say that he saw that part of the fight. All he knows is that his friend got a phone call saying that the driver was in trouble and that they all rushed down. So from his perspective, the rules have to be applied, not from the perspective of someone who can watch the videotape and see everything that's involved. My viewing of the videotape, which I think is equally as irrelevant as the trial judge's viewing of the videotape, is that the driver is an aside. I mean, he may have been right there, but the real fight, Perez doesn't even consider him much of anything.
So if we were writing this and agreed with you that there's a disconnect between looking at that video and viewing the video as a video viewer versus hearing what the defendant says and viewing it from the defendant's point of view, what would we write to tell a trial judge that that's how we make that's a distinction we should make?
Exactly what you said, Your Honor. That it has to be from the defendant's perspective, that he can't ignore what the defendant said, no matter how improbable he thinks it is, while viewing the videotape.
Can the video fill in gaps, factual gaps, though?
Yes, but I go back to my position that the inferences that can be drawn have to be drawn in favor of the defendant. So, I mean, this is about as stupid a murder as you can get.
On your second issue, did the judge strictly apply what we said in Canine and Hunter and all those cases as far as suffering goes, so there was no error, or should we change Canine?
So I think you should change Canine. I've been doing this for a long time.
But do you think the judge got it right as far as it goes?
Yes, to some extent. I think he should have said There's not enough, the judge believed that the only canine factor that was really at issue in the case was conscious suffering. And he said that was a close call. So he should have given, in my view, a required finding of not guilty on murder in the first degree based on extreme atrocity and cruelty, because if that was the only factor that he thought was in play, I say as a matter of law that factor wasn't strong enough to, that no reasonable juror could find that factor beyond a reasonable doubt.
You make the argument that the amount of suffering here is, standard shootings death. I'm oversimplifying what you're saying, but look, this is like any other time someone is shot and killed. There's nothing extreme. Is that going to require us to change our case law on what we consider sufficient to meet this standard? Because we have a number of cases out there, right, where we have fairly ordinary shootings and they bleed out slow, not exceptionally fast or slow. I guess I'm trying to get a sense of, are you asking us to change that law as well?
So yes, I'm asking you to adopt the Berry concurrence and to throw out this canine factor.
But the concurrence focuses on the intention of the defendant.
Right.
I thought you were focusing on a different point, that this is an ordinary shooting. It's not, a hatchet murder or something where you've got, a grotesque amount of.
Right. So I asked for a number of things. One is that there should have been a required finding. Second, that the judge should not have listed all the canine factors. He listed them correctly. But if he believed that there was only one canine factor in play, he should have focused the jury's attention on that factor and only that factor. And I also say that we should change the law. And I also say under 33E review, if you reject all of those positions, most of us have seen really atrocious and cruel killings. And this is not one of those. If you watch the video, he takes one shot towards the lower body and moves away. And senseless stupidity with blame on both sides, but extreme atrocity and cruelty. And the only evidence of conscious suffering is that he said, I'm hurt, to the first person that came by. We see him run away, and then he collapses. I'm hurt. And then there's this stuff that the EMT sees, but there's no medical evidence that this is conscious actions.
Aren't there cases like that where that's enough?
If there are, they should be overruled. I mean, we're not talking about the difference between first-degree murder and acquittal. We're talking about the difference between first-degree murder and second-degree murder. First-degree murder is life without the possibility of parole. It seems to me it should have some reality to it, some substance to it, something that we can put our hands on.
How would you distinguish this from other single-blow cases?
Well, to me, a single blow with a hatchet to the face is one thing. A gunshot to the torso seems to me to be just so ordinary.
Not to be too picky or graphic, but the hatchet to the face could knock somebody out instantly, whereas
Right.
a gunshot and they're conscious and bleeding to death, they do have conscious pain and suffering.
Well, maybe. I mean, there might have been some medical evidence in this case if the Commonwealth had asked the medical examiner to explain what happens when you bleed out from having your abdominal aorta severed, and whether these actions that he did of sitting up and moving his hands were at a level of consciousness. This record just doesn't have that. And so is someone that puts a gun in your mouth and kills you instantly a kinder, more decent person than someone that shoots you in the torso, and the way luck works, you bleed out. So again, I'm not suggesting that someone should be acquitted. What I'm suggesting is that we should have some meat in this concept of extreme atrocity and cruelty, so that when we see a case, we would say, yeah, that has some meaning that really differentiates itself from other run-of-the-mill cases.
The distinction seems to be our focus on that which is defendant conduct directed and victim impact directed. And I take it that you're arguing the focus should be more on what the defendant did than as opposed to the consequential effects of what happened to the victim.
I think so, at least in most cases. It seems to me what we want is to punish behavior on the part of the defendant and say this behavior is so bad that we're going to call it first-degree murder, just like you formed an intent to kill, thought about it, deliberated on it, and then executed that intent to kill. Instead, we have this mishmash of canine factors, and I could have had somebody on this jury, it wasn't my jury, but the defendant could have had somebody on this jury that is so against guns that they just consider it, extreme cruelty to use a gun. And, or that, the suffering that the person went through somehow reflects back on the defendant. I don't see what the purpose of that is, if what we're doing is punishing behavior by the defendant. I mean, this young man is not a marksman. If the bullet had gone in 3 inches in that direction or 3 inches in that direction, it might have just been an armed assault with intent to murder.
How does the element of malice aforethought work with this extreme atrocity and cruelty argument that you're making? Because there's still a requirement of finding malice.
Right. It's
So
still
it doesn't-
that's second-degree murder.
Right,
You find
but
malice, you've
it's a
got
component of
second-degree
this.
murder. And, that's life with the possibility of parole. And now the question is does it get elevated to first-degree murder? Do we see this in the same light, basically, as premeditated murder? And it seems to me there should be some real substance there if that's what you're going to do. I mean, what I've watched happen over the decades of my practice is this court has totally straightened out the concept of malice and the concept of premeditation. And most of these defenses, in a way that didn't exist when I was here for the first time in the 1970s. And, but this is the part that you haven't grappled with significantly, or significantly enough, at least from my perspective. This is the worst label we can put on somebody. And I don't know how anyone can watch this video and decide that this person has acted with extreme atrocity and cruelty.
Now, how constrained are we by the judge's conclusion that that one canine factor was what was at play?
So you're not. I mean, if he was wrong, if there were other canine factors at play, then you can affirm on those grounds. But that's the way he viewed it, and that's the way, if he was right, and I think he was, although most of these canine factors have no real substance. The number of blows, it can be one. The amount of force used, as I say in my brief, doesn't matter whether it's a high caliber weapon or a low caliber weapon. We have these evidentiary considerations that are really not really guidelines. They're just window dressing.
If I can bring you back to the excessive use of force in self-defense, are we obliged to view it from tunnel vision, or are we obliged to view it from the vantage point of the defendant? Must we accept the view that the defendant only saw what he saw?
Yes. That's my position, and based on the case law.
Well,
No matter.
it says a reasonable person in the position of the defendant
Right.
You interpret position of the defendant to mean only what he claimed he saw, or what a reasonable person in that position would see?
Only what he claims he saw. So the jury can reject it. Obviously, just because you're entitled to an instruction doesn't mean you're going to win the case based on that. But I think you apply the objective standard to the circumstances known to the defendant. So whether he was negligent or blind in one eye or deaf.
What about the fact that he has incomplete knowledge? And he should objectively know he has incomplete knowledge. He didn't see the beginning of the fight. Does that matter?
So I think what matters is in the circumstances that he did know, whether a reasonable person would believe that.
But if a reasonable person who didn't see the beginning of the fight knows he doesn't know the whole story here, and before he pulls out a gun, does that matter?
So in my view, it doesn't matter because this is what happens most of the time when a third party comes by. They don't know all the circumstances. They don't know what was said initially. They don't know who did what. What they come upon is
Is that really the case? Because most of the cases I've read, they seem to be coming to the aid of somebody. They're present the whole time. It's not like this guy who gets a phone call and runs in. This is sort of an odd defense of another case, isn't it?
I don't think so, but it's your view that matters, not mine.
Well, not just mine.
So,
There's others.
I don't think it's unusual for people to be in a circumstance where they think they need to aid another person and they don't know the whole story. They don't know what really happened initially. They don't know why this is occurring in front of them. The question is, do you want them to keep on walking and sort of, close their eyes to what they see immediately in front of them? Or do you want them to make objectively reasonable assumptions based on what they actually see? And the way our case law is, we ask people to make reasonable assumptions based on what they actually saw.
Any obligation to attempt to remove the third person from the scene as opposed to shooting the other guy?
So, as I said at the beginning, I think my best argument is that he was entitled to an excessive force in self-defense.
It still has to be appropriate self-defense.
Right, but this is a strange defense because you do not look. In other words, I could act in defense of another in circumstances where the other had no right of self-defense. And I could have no right to act in defense of another in circumstances where the third party had the right of self-defense.
Right, but if you, as a defendant in that situation, came upon a field and there were two parties there, and you saw that he was in an open field, of course you wouldn't have, right? Because you would know that the person you were defending had a right to retreat, and it was no big deal.
Right, he would have a right to retreat unless he was dazed from a punch that he'd already received and his knees had buckled, and it may not be possible realistically to retreat. So there are circumstances where, even though the possibility is there.
And it added to this whole scenario is the right to use deadly force in a fist fight.
Right, so that's why I say my best argument is he was entitled to an instruction on excessive force in self-defense, in defense of another, which results in a manslaughter conviction, because it seems to me one could argue that the reasonable person would have known that this was excessive force. On the other hand, if you watch the whole video, this person that got killed was a very tough person, and he's no shrinking wallflower, and his friends are doing the best they can to constrain him, and they can't constrain him. At one point, Mr. Tang, I think his name is, walks into the camera and says something like, "I can't do anything," or something like that. I'm not so sure that this was not going to end without the gun in a way that was not going to cause grievous bodily injury to the driver and Marlon.
Okay, thank you.
Thank you.
Mr. McLean.
Good morning. May it please the court. Ian McLean on behalf of the Commonwealth. This court should affirm the defendant's convictions because first, he was not due a defense of another instruction where his friend was the initial aggressor in a fistfight with an unarmed man and continued that fight. And second, there was ample evidence to establish the canine factors here for the extreme atrocity or cruelty theory.
What do we do with the fact that he doesn't know how the fight started?
Well, respectfully, Your Honor, we have the video, and the video, as the trial judge noted, the video shows him standing directly
I know
in front of the
we
two.
know with the video, but we know he doesn't know because he's not there in the beginning, right?
Correct, Your Honor. Correct, Your Honor.
What do we do with that?
Well, even if you were to completely accept his testimony that he was focused entirely on the victim and didn't see Marlon initiate.
I'm just, you made the first point, we got an initial aggressor, but he doesn't know who the initial aggressor is.
Your Honor, he did testify. I'd point you to volume 6 at 137. Marlon goes after them, right? Correct. So volume 6 at 137. He did indicate that he was aware that his friend Marlon was moving forward towards them. And then also at 114, the same basic testimony, he was aware that Marlon moved forward at him.
Did the judge err in over-relying on the video as opposed to focusing solely on what the defendant said?
No, Your Honor. No, Your Honor. So the evidence is viewed in light most favorable to the defendant. He gets all reasonable inferences, but the video is the best possible evidence of what actually occurred there. There's a point at which the inferences that they're asked to draw are not reasonable. The video shows exactly what occurred and shows the defendant there seeing what occurred.
But you have to look at everything the defendant says and accept it as true, correct?
In the light most favorable, yes, Your Honor. So if you accept his testimony as completely true, then he didn't see his friend as the initial aggressor. So if we're going to go under that route, then what we have is his friend as a voluntary participant in a combat situation. So I point you to Barbosa and Adams, where when the potential protectee is a voluntary participant in a fistfight, that can't be the basis for the defense of another instruction because he was choosing to be a part of this fight. So here, the Marlon Ramirez received a punch in the initial exchange, which backed him up, and then he moved forward and re-engaged. So at that point, there's no question that he is a voluntary participant in this situation. So we're squarely within the realm of Barbosa and Adams.
Did the defendant testify that he saw the Marlon pinned against the car?
No, Your Honor. I don't recall any testimony about...
his friend pinned against the car?
I don't recall any testimony about him seeing his friend pinned against the car. And the video clearly shows that, and as the trial judge noted, the video shows that there was ample space behind Marlon Ramirez where he could back up and leave the situation at any point in time. It was the victim who was backed up.
I messed that up. The victim was pinned against the car. What did the defendant say about that, if anything?
I don't recall him testifying about that at all. But so then, Your Honor, that would be a gap in the testimonial evidence. You can look at the other evidence, which is the video that shows him backed against the car. So that's where you can fill in that gap. So even in the light most favorable, the video shows something that the defendant didn't testify to, so you look at the video for that evidentiary piece. So here what we have is Marlon Ramirez engaged in a fist fight with an unarmed man, a fist fight that he started, but if we're not going to accept that he started, that he was certainly a voluntary participant in because he re-engaged in it. So all of the evidence was that the only person armed with any weapon at all here was the defendant. The defendant himself admitted that he was the only person with a weapon.
But in the light most favorable, again, I'm not questioning, but the light most favorable to the defendant hears that the victim is a martial arts expert or something like that. He's a UFC fighter or whatever that terminology is, right?
Well, Your Honor, I think you're going beyond the record there. So
So that's not, that is not stated during the fight that I am a UFC fighter?
The testimony was that the defendant heard the victim say, "I am a UFC fighter," one time, and then someone in the crowd of people around repeating it or reiterating it or something.
But
to that
again, I'm
effect.
just trying to put this in the light most favorable to the defendant. And correct me if I'm wrong. The defendant hears that the victim is a UFC fighter. The victim is getting the better of his friend, right? He's beating him up at this point.
2 punches, Your Honor. And in both of those punches, there was an exchange from both parties.
Okay, but I thought, again, correct me, the friend is down, or he's down, he's got back up, but he's down again, right?
Not down, Your Honor. What Marlon Ramirez testified to was the initial punch that he received backed him up.
Right,
and then he re-engaged. And that's basically what the defendant testified to.
And when he re-engages, doesn't he get clobbered again?
I take issue with the word clobbered, but
You just put it in your words.
yes, Your Honor, the initial punch was a right, and then the second punch was a left hook, is what the record shows.
And,
So-
and the friend is staggering at this point. Don't put my words. From what I understand, in the light most favorable to the defendant, his friend is fighting a UFC fighter and is getting beaten up. And then he pulls out a gun. I'm not saying that's enough for defense, but that's in the light most favorable to him, isn't it?
Okay, Your Honor, but I would point you to Mattei, the Mattei case from this court in 2010, where portions of the human body cannot be enough to be a deadly weapon. So hands, unshod foot, teeth, there's no external instrumentality there, so it's
But
not.
I think Mr. Sheketov's conceding we've got excessive force here. But I guess the question is there defense of another in this circumstance?
So, Your Honor, we conceded at the trial level and we concede here that the subjective prong, the subjective requirement was satisfied. But the question then becomes whether that's objectively reasonable. And here it's not. His friend had received 2 punches, withstood both of the 2 punches, re-engaged after the first punch. He wasn't knocked down in any way, shape, or form. There was no testimony that he was even bloodied by the 2 punches. So, a fist fight with an unarmed man that he initiated and re-engaged. And under Barbosa and Adams, we've got at least a voluntary participant if we don't establish that he was the initial aggressor. So that can't be the basis of a defense of another instruction here. So neither of the 2 objective requirements were satisfied here. Turning to...
What is before we leave, I was looking at the objective requirements with regard to the self-defense instruction, but what are the objective requirements with regard to the defense of the use of excessive force in self-defense? Because that doesn't require deadly force. That simply means you had a right of self-defense and you used more force than you should have.
Well, it still would be defense of another here, Your Honor. So we
Right,
have
of
to...
course. But what is I was focusing on the defense of another, which could be saved only by deadly force. But if you have excessive use of force in self-defense, it takes deadly force out of it, and the question is whether or not he would have a right of self-defense, he would have a right to use some degree of force in defending a third party.
Yes, Your Honor, but there are still objective requirements. The defendant's subjective belief has to have been objectively reasonable that he needed to step in order to defend the protectee, Marlon Ramirez here. And as an objective person in the defendant's situation, it's simply not reasonable that he needs to step in and defend him at that point. He is a voluntary participant in an unarmed fistfight.
So what would be reasonable from the point of view of the defendant in this circumstance, in terms of what he reasonably should have done as opposed to what he did?
Step in and try to break the 2 apart. Here, what he did was draw his loaded gun and introduce his loaded gun into a situation where there's a crowd of people and fire into the crowd. Not a reasonable choice here at all. He was not due a defense of another instruction under those facts.
At that point, it was 2-on-1 as well, right?
Yes, Your Honor. So from the video evidence, you can clearly see that it's 2-on-1. His testimony doesn't necessarily concede that it was 2-on-1. But the two people...
But objectively speaking, Lopez was involved as well.
Yes, Your Honor. The 2 people backed the victim up to a point where he had nowhere to go at that point, and then that's when the exchange of blows occurred.
Could we shift you to the second issue? So, when Mr. Sheketov argues, our jurisprudence on extreme atrocity and cruelty is kind of simple-minded, and we need to fix it. What do you think?
No, Your Honor, it doesn't need to be changed at all. When this...
But I guess, let me add one sort of set of... This is I'm not saying any shooting isn't going to be painful and death ensues, but how do we distinguish this from any other, shooting where someone's killed? It just seems it's a one-shot death, right?
Yes, Your Honor, it is a one-shot death.
Dies pretty quickly.
I would disagree with that characterization, Your Honor.
And it would be most helpful for me. Do you have some cases where we've got this kind of shooting or single blow murder and we find extreme atrocity and cruelty that I can look at? Because it does seem like this is not out of the ordinary.
Yes, Your Honor. Anderson from 2005 compiles a list of single blow cases. Anderson was essentially an execution style murder, but it compiles a list of single blow cases within Anderson. And what I would point you to here specifically for the Canine factors in this case is Smith, where in Smith it was a strangulation case, but the evidence there was that the victim was awake and conscious for at least 30 seconds. So the victim was aware for that period of time of the suffering she was undergoing before she eventually
No, but
died.
she's being strangled for a longer period of time, right? Takes a while.
Yes, but the evidence was that she was conscious for between 30 to 60 seconds before she became unconscious. So the Canine factor that goes to the victim's consciousness and the awareness of the
If you're
suffering they're
in
undergoing.
pain for 30 seconds, that's enough for extreme atrocity and cruelty?
Can be. It's a jury question, Your Honor. It's a jury question. And in Smith, it was enough. Excuse me.
Is part of the extreme atrocity and cruelty the consciousness of the victim and the awareness that they're being killed?
Yes, Your Honor. Yes, Your Honor. And that was the exact point in Smith. And here, that's exactly what we have. He was shot. He staggered for approximately 20 feet, saying, I'm hurt, before he collapsed to the ground. And then there were multiple witnesses that testified to his shallow and labored breathing once he was collapsed on the ground before the EMT arrived. Once the EMT arrived, the EMT then provided further evidence that he was conscious and aware of his suffering, and that on multiple occasions, he attempted to sit up, opened his eyes, and reached out to grab something. That's a conscious act, attempting to grab something. So the EMT specified, he tried to grab my wrist and arm. That's at volume 4, page 240. So that's a series of occasions after he staggered 20 feet, aware that he's hurt, and collapsed to the ground, and then the amount of time it took the EMT to arrive, and then him to sit up at the scene more than once and try to grab something for help. Then the EMT testified that he engaged in the same behavior while in the back of the ambulance and being transported to the hospital, and then at least 2 more times once he was receiving treatment within the emergency department itself. That's a victim who's alive, making conscious actions, indicating he's aware of his suffering for several minutes at least.
I don't want to diminish the gravity of the crime or impact on a victim, but would you agree this kind of depends upon happenstance? You know, were the defendant a better shot, he wouldn't get this instruction?
Potentially, Your Honor, if it was a single shot between the eyes and the victim died instantaneously, potentially that wouldn't qualify for extreme atrocity or cruelty. But the legislature, when they crafted this...
Or if he, you know, struck the aorta in a different manner. I mean, so basically any shot to the stomach or gut shot is going to lead to this instruction?
Potentially, Your Honor, but that was the legislature's decision when they crafted the murder statute. They included the intent...
That was us. So it's a common law crime. So we're the ones that define what constitutes the elements of the legislature. When they enacted the statute, that's purely punishment. We're the ones that decide what the common law of murder is.
So, yes, Your Honor, 265.1 indicates malice aforethought as the necessary intent element, and then uses the statutory language extreme atrocity or cruelty, almost like an aggravator. So 3 different ways you can commit murder that warrants a murder 1. The deliberate premeditation, extreme atrocity or cruelty, or the felony murder.
But just like malice is a term of art, and we define what malice is, we also define what atrocity or cruelty is, right? It's purely a question of common law.
Well, respectfully, Your Honor, I think it's a question of statutory construction. We have a statute that is this offense, and that statute uses these words, extreme atrocity or cruelty. This court in 1983 in Canine defined those words, extreme atrocity or cruelty, with 7 components. We refer to them as factors, the Canine factors, but really it's the definition of atrocity or cruelty. So, and what's our standard process for statutory construction? What's the plain and ordinary meaning of the statutory language? Cruelty, the plain and ordinary meaning of that language is the first Canine factor, indifference to or deriving pleasure from the suffering. So then we're looking at the other word, atrocity. So how do we define atrocity? Atrocity is not focused on the actor, on the defendant. It's focused on the victim. It's focused on how the victim received the blows, how the victim died. So
It still has to aggravate that. I mean, the way to look at it, or one way to look at it, is all murder is second degree. And now we're looking at aggravating factors.
Correct,
And right in our instruction, it says it has to be that which is beyond the inherent atrocity in taking a human life, right?
correct, Your Honor. So you could use a gun and shoot someone square between the eyes and kill them instantly, where they wouldn't be consciously aware of the suffering, and they wouldn't experience the suffering. The legislature determined here that there are manners in which the murder can be occurred, and how the victim dies, how the victim experiences it, and how they die is enough to elevate the crime to a first-degree murder.
But aren't we going to have I mean, if we look at all the second-degree murder cases out there, we had better medical testimony. You could convert almost all the second-degree murders into meeting the cruelty definition, right? If we can find 30 seconds of suffering in these second-degree murder cases, aren't they all potentially meeting the atrocity requirement?
So potentially, Your Honor, but let's break them out between.
So then doesn't it become somewhat arbitrary if who gets second degree and who gets the extreme atrocity?
No, Your Honor, and it's a jury question. So the facts are going to be different in every single case, and the inferences that the jury draws are going to be different in every single case. Here, we're basically doing a sufficiency review of what the jury looked at. And here, under this set of facts, this defendant suffered for a period of minutes.
But I think you're I mean, I haven't read the Anderson case you're talking about in a while, but if we can find 30 seconds of suffering, that's enough for atrocity, in your view, right?
It can be, yes, Your Honor. Yes, Your Honor.
So if you don't think we're going to be able to develop that kind of medical testimony in almost any murder case?
Just because it can be in one case doesn't mean that it will be in every case.
That becomes an issue of prosecutorial discretion then, whether you bring that charge or not.
Well, I respectfully disagree, Your Honor. You're assuming it's a foregone conclusion, and I don't believe it is a foregone conclusion.
So what if someone gets stabbed in the leg, and then they go to the hospital and they're stable, and then 3 weeks later they get sepsis and they die from the infection, and it's very painful? Is that extreme atrocity or cruelty?
No, Your Honor, I don't believe that is extreme atrocity or
Some
cruelty.
suffering involved, right?
Yes, there's suffering involved, but there you're talking about the course of treatment and the medical intervention and how that affected the course of treatment. So what you would be describing there is a single stab wound to the leg that ultimately resulted in death down the road. Categorically different from stabbing someone.
Because the single blow cases have been a knife that's twisted. There was a racial attack where there was indifference. The defendant said whatever, it said something flippant about the victim. They're showing some indifference with a baseball bat. Aren't the single blow cases kind of unique in this area? Because the normal, as Mrs. Sheketoff said, the normal atrocity cruelty case kind of screams out, right? It's the 13 stab wounds, and we all have seen that.
Well, yes, Your Honor, but just because one case cleared the hurdle by multiple feet doesn't mean other cases don't also clear the hurdle. I would point the court to Anderson, which was the case that cited glass, I believe is what you're referring to, about the knife wound, that then the twisting of the wound itself. The Anderson case was an execution-style murder, where there was no evidence that the victim survived beyond the immediate moment of the gunshot. So there, the consciousness of what was coming, being aware of it as the person is drawing the gun, putting you on your knees, and then ultimately pulling the trigger, that doesn't last for minutes.
Because in all those cases, to aggravate that which is second-degree murder to first, you clearly have premeditation.
Well, yes, Your Honor, but that's a separate and distinct theory that plays.
No, I get that, but if we're talking about culpability, there is an avenue for culpability.
Well, so here you have a defendant that drew the gun, that for his own testimony, drew the gun, decided not to use it, put it back, drew the gun again, and decided to use it.
I think in this case, there was premeditation, and maybe there was a tactical error for the prosecutor to rely on atrocity cruelty.
Both theories went, Your Honor. So I would also point you to a second.
Am I correct? You focused on the statutory language. Am I correct that when extreme atrocity or cruelty was included in the statute, it was the difference between somebody being put to death and somebody not being put to death?
Yes, Your Honor. But what I'd point you to is when this court construed that statute, engaged in statutory construction in 1983 in Canine, which is 37 years ago now, the legislature has not since stepped in and changed the statute. So I'd point the court to, as Justice Budd wrote in Mata just this past year, when you've construed a statute specifically having to do with an intent element within a statute, and that there are decades of decisional law as a result, and the legislature never steps in and changes the statute, they've adopted your construction of the statute. So here, over the course of that 37 years.
Put that aside. But I mean, don't we need to look at extreme atrocity or cruelty in terms of when it was enacted at the time the legislature enacted it, as that which the legislature considered to be that which distinguished a case in which a person can be put to death for his or her killing, as opposed to a person who could not be put to death?
Yes, Your Honor, but what's important now is that in 83, this court said, here's how we're interpreting this statute that you've created. And the legislature since then has been silent to that. They have adopted your interpretation of this statute that was announced in 1983. So what we have there is,
Well, if that's the case, we would never be revising anything to do with our common law of murder, because we would always say that the legislative inaction constituted ratification, but we've not considered that our common law of murder is to depend upon the legislature changing it. We've basically said this is our domain, and we will be interpreting the meaning of premeditation, the meaning of malice, and the meaning of extreme atrocity or cruelty, haven't we?
correct, Your Honor, I see that my time has expired. Can I respond?
You may answer.
So the first place that I would point the court is to Motto, and just this past year, the court embraced that approach, that once you've interpreted a statute and the intent component of that statute and the legislature is silent, they're endorsing
Is that a
your
common law
interpretation.
statute, by the way?
No, it's not, Your Honor. So then the next place that I would point you is the legislature being aware of the decisions that they're making. I'd look at, as an analogy, I'd look to indecent assault and battery on a child under the age of 14. There's an intent component in the crime, and then essentially the aggravator, the under 14, carries no intent component. It's focused on the victim. Just like here, the aggravator component of murder, extreme atrocity or cruelty, is focused on the victim. Cruelty looks at the state of mind of the defendant, whether he was indifferent to the suffering or whether he enjoyed the suffering he was causing. But that's not adding an additional intent element. That's his state of mind after the act has occurred. Atrocity focuses on the victim, how the victim experienced what happened to them. So this court's interpretation in 1983 in Canine was correct. You looked at the two words and identified what those two words meant, what it took to qualify as the aggravation to get it up to a first-degree murder. So it shouldn't be revisited because you did it correctly in 1983.
But well, let me ask you, I mean, it's extreme atrocity. It's not, I think one can say that all killings, all murders are both cruel and atrocious, but we're speaking about those which are extremely atrocious and cruel. Let me ask you this. Put aside the issue of premeditation. A person who puts a gun in the mouth of somebody and blows them away so that it destroys their brain immediately and they die, versus the person who shoots somebody in or around the hip or in the leg and they die 4 hours later. Which is more atrocious?
Not a question I'd like to answer, but
That's why I'm afraid you have no choice.
Your Honor, the definition that this court has put forward under Canine is atrocity or cruelty. So the person that's doing that sort of execution-style murder that you're describing, I think that's probably going to fall under cruelty, and it's going to be similar to the Adams case, where if the victim is aware of it, so under your hypothetical, they place the gun in their mouth, so the victim is aware of what's happening, what's about to come to
Let's
them.
assume they put the gun behind their head and they shoot them.
Well, now we're outside of the atrocity realm, most likely, because the victim's not aware of what happened to them. So there's no conscious awareness of
It's
what's
not,
coming.
if basically somebody walks up to somebody from the rear and does an execution-style killing and shoots them, being a professional, shoots them in the head so they die instantly, as opposed to the person who's hardly a professional and shoots somebody in the leg or in the hip and they die a day or two later, which is more atrocious?
The latter.
Really?
The first is going to be pursued under a deliberate premeditation theory.
I know
And
that,
I'd say
but that's a separate theory. Certainly if anybody's to be found guilty of that, then we will deal with it as a deliberate premeditation. We're dealing with cases only which, for whatever reason, the jury did not find deliberate premeditation. And now the question is whether or not, at least when the statute was enacted, that person should be executed for his or her crime. Don't we need to consider it in that light?
I would point the court back to Adams again, the single blow execution style. What was the crucial factor there was the victim's awareness of what was coming to them. So in the hypothetical you pose, the victim is completely unaware. It would be just like shooting someone from a long range distance with a high powered rifle and all of a sudden the lights turn out and they're deceased. They're never aware of what happened to them. So then the question whether it would qualify for extreme atrocity or cruelty is whether they were indifferent to the suffering or whether they took pleasure from what they were doing to the person. So they could potentially satisfy extreme atrocity or cruelty under that portion of the definition, but that distant shooter or that creep up behind and shoot you in the back of the head probably doesn't meet the atrocity aspect, because the atrocity aspect focuses on the victim and how they experienced the death.
So it's not the conduct of the defendant as much as the experience of the victim.
This theory of aggravating a murder to first-degree murder is focused on how the victim experienced it. And that's a policy decision about there are some crimes that it matters how the victim perceived it, as opposed to the act that the defendant engaged in. The act that the defendant engaged in here is captured by the intent element, the malice of forethought.
Okay, thank you.
Thank you.